I'm going to start off with a land acknowledgement, and in that spirit, sort of understanding the spirit of that land acknowledgement, I think is so incredibly important because it really is a beginning and named as a beginning for reconciliation, and that's really about establishing mutually respectful relationships between Indigenous and non-Indigenous peoples in Canada. And obviously, for that to happen, there really must be awareness of the past and recognition of the present day impacts of colonization. There are people in Canada who have been removed from the land and people who have had the land taken from them. And all of us really must listen and self-reflect on how it is we are situated in that history and work to understand and acknowledge the history and the current day's issues of Indigenous perspectives. And that includes acknowledging the pain and trauma of generations of Indigenous children and families, and also acknowledging that the land honors the authentic history of North America or Turtle Island and its original people, and tells the story of the creation of this country and that has been historically missing in many instances. So myself, I grew up in Montreal. I have family that came to Nova Scotia in the early days, so would be seen as a white settler. And in that sort of situating myself in that history, I'm really mindful of the promises and agreements that have been made and broken over the years. And, also I understand that there are really differing perspectives within Indigenous communities too. There isn't one way to look at this from any perspective. And so I really am committed to taking action both personally and professionally in my life, and continue to do that wherever I can. So in that spirit, I'd like to offer the land acknowledgement today, and I want to honor the land that we are meeting on in Toronto here at the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people. And it's now home to many diverse First Nation, Inuit, and Métis. It's covered by Treaty 13, signed with the Mississaugas of Credit, and the Williams Treaty, signed with multiple Mississaugas and Chippewa bands, and is the territory subject to the Dish with One Spoon Wampum Belt Covenant. And that is an agreement to peaceably share and care for the Great Lakes region, the land, the people, and all the creatures that live in this area. So that's the land acknowledgement. Thank you for listening to me. And I hope that through that, we also self-reflected in thinking about our own experiences within that history, and, make it more than something we just do rote, but really think about. So thank you. I also want to do an introduction to the Human Service and Justice Coordinating Committee. Some of you are part of that committee, and some of you may be part of the system that we are all working within. And just want to make you aware of what the mandate of the Toronto Regional and local HSJCCs is, and it's to engage in joint cross-sectoral planning, coordination and integration of services for individuals with complex human service needs, which may include, but are not limited to, those living with mental health issues, substance use concerns, and/or behavioral dependence, or neurodevelopment and neurocognitive disabilities, including developmental disabilities and dual diagnosis, and at the same time are involved in a significant or at significant risk of being involved in the criminal justice system. There are 4 local HSJCCs. Actually, there's 3-ish. Well, there's still 4, but we've combined 2 of them. One is the downtown HSJCC. The west and the north are remaining unique, but meet together. And we also have a Scarborough HSJCC. And then we all come together to do more planning as a broader region. And along with that, there is a provincial HSJCC that we all feed into as well. So if you are in Toronto and are interested in joining the Toronto Local HSJCC's committee, please respond in the chat box with your email and which local you want to join. And our coordinator, Dominica DeLeo, who is here as well today, will get back in touch with you about how you can do that. So everybody's all great in line already, that got yourself muted and your video off. It serves 2 purposes: a little bit clearer in terms of presenting, and also an opportunity for you to eat lunch, which is one of the goals of today, both learning and eating. So thank you for doing that. We'll ask you to do that. And we're going to hold most questions until the end. But if you do have questions as you're going along, you can pop them in the chat. And Dana Riley, who is also a co-chair for the Scarborough HSJCC, will be monitoring the chat and will help to make sure that those questions get addressed as we go along. And what else do I have here? Yeah, we wrote them in chat. If the session is recorded, it can create complications regarding consent, so we do not record the session. But participants are informed that if you're calling in and can't use the chat, please email your questions to Dominica either before the session begins. So I think that's already done. So that's wonderful. And Caitlin is pretty open to taking questions along the way, but we do know with large groups that can sometimes be challenging. So I think Dana's going to help moderate that as we go. And I'm going to pass it over to you now, Catherine, for making this connection for Caitlin and providing an introduction to her. And I have to apologize, I'm not going to stay for the whole event, but really I'm so grateful and look forward to hear how it goes. So best of luck, everybody, and thank you for joining us today.
Okay, thank you so much, Susan. Welcome, everyone. It's my very great pleasure to introduce our speaker today, Caitlin Buchel. And I just wanted to back up a little bit and just explain a little bit about how this all came to be. Many of you know me. My name is Catherine Wiseman-Hakes. I'm a speech and language pathologist and an assistant professor at McMaster University in the speech and language pathology program. And I do a lot of work in the area of communication and neurodisability among individuals who are marginalized and underserved, with a primary focus on those within the criminal justice system. And we're aware that the prevalence is very high, and I know that Caitlin is going to speak to that. So a couple of weeks ago, we had a wonderful presentation from our colleagues from MAG, who spoke about the accessibility coordinator role. And not surprisingly, they identified that communication intermediaries are the number one request from the perspective of accessibility. I also wanted to share that the role of communication, the recognition that communication is a huge barrier within the criminal legal system, is recognized internationally. And there are a number of international models where speech and language pathologists, speech and language therapists are actually embedded into the criminal justice system teams. For example, in the UK, England, Scotland, and most recently Ireland has come on board, Australia and New Zealand. So I'm just so thrilled that as Canadians and in Ontario that we are really starting to recognize the importance of the barriers of communication. And that is how we came to bring Caitlin here today. On a personal note, Caitlin is a dear friend and a valued colleague, and I'm delighted. So let me tell you a little bit about her. So like me, she is a registered speech and language pathologist, and she's a communication intermediary, and she is the founder and executive director of Communication Access to Justice. So the short form is CAJust. And this is a national nonprofit organization that promotes access to the justice system. So that includes police, corrections, courts, for all people who have speech, language, or cognitive disabilities. And I just also noted when Susan gave her introduction and overview that she spoke about people with neurocognitive challenges. And I would like to advocate for we have communication embedded in officially within that, because I think people don't recognize it. So language and or cognitive disabilities. So in that capacity, Canadian Access for Justice trains, supports, and publishes a national list of communication intermediaries who neutrally intermediate between victims, witnesses, accused persons, and justice professionals. Caitlin is also an expert consultant speech-language pathologist on Manitoba's medically assisted dying MAID team, and she lives and works in Manitoba, so she's joining us from there today. So it's my great pleasure to introduce you, Caitlin, and welcome. Just quickly, I am going to leave my camera on so that just poor Caitlin doesn't feel like she's talking into a vacuum. That she does see one face. So that's why my camera is on. But a friendly reminder that we are asking everyone else to please turn their cameras off. So thank you. Welcome, Caitlin, and over to you.
Thank you so much, Catherine. I'm thrilled to be here, and I do just want to send a note of appreciation to Catherine, to Dominica, to Susan for their graciousness. I had a bit of a family medical emergency. My son Finn, who is now totally okay, but as anyone who has kids knows, they sometimes get very, very sick very, very fast. And so in having to cancel in December, I do just appreciate what a busy time that is and how you may have set that time aside. And so I do just want to acknowledge that and say that I do appreciate your patience with me if you had planned to attend in December. And the one thing that I probably am more passionate about than my work is my kids and my family. So I appreciate your understanding, and I'm thrilled to be here and so appreciative to the organizers for allowing me to come back today and to speak to you. So as I was sharing with Catherine and Dominica and Susan before we started, I'm not an expert at Teams, so I am going to start and try to share my screen here with you, but I appreciate your understanding. I don't have any excuse. I should be better, but I'm going to throw us into hopefully presentation mode if we're lucky. And I'm hoping that you have a full screen view of the presentation. Fantastic. And I see Catherine giving me a thumbs up, which I do appreciate. Okay, so I mean, that was a lovely introduction, and so I don't really have too much to say about myself, but I would like to kind of jump in. So we thought a little bit about what the learning objectives should look like for today. And so I know you're familiar with them, and I won't spend a ton of time belaboring them, but I do just want to help to define a little bit this concept of a communication intermediary, what they are and what they're not. And then now, I am by no means an expert, and I'm thrilled that you were able to have the Ministry of the Attorney General and their accessibility group come to speak with you, because certainly they, that's what they do. But I will speak a little bit about because I think it's all equally important that individuals with communication disabilities and those who support them have some of this knowledge, because as much as there may be, and there actually are, especially in Ontario, quite a few laws and regulations and standards in place. Unfortunately, there's still lack of knowledge and awareness of what those are in especially in some frontline policing and even within courthouses. So having that information, I'm going to give you a little bit to hopefully arm you with some information that you can share if there is a lack of awareness. But again, I'm by no means an expert on the AODA. But I want to share what I know. And then we'll talk a little bit about, throughout the presentation, about what some of the challenges and barriers are for individuals when they do have a communication disability. And I'll touch on at the beginning about what that is, how I'm defining that. And then I've included some practical strategies at the end. I'm sure both Catherine and I, and I know that Catherine has actually, and her colleagues have developed, a whole program, for example, for training police officers in how to work with individuals after traumatic brain injury and have those interactions. So again, we could spend a day and probably days talking about how to do that, but I've tried to give you a few first steps, first tips to kind of get started and have some ideas. So without further ado, there's our plan for today. So this is kind of how the presentation will run through. And I'm going to just jump in as opposed to reading it to you and then doing it again. So CAJust, Catherine hit on this. So we're a national nonprofit organization. I do want to, tip my hat, as it were, to the organization that, really came before and still exists. So Communication Disabilities Access Canada, sort of like trying to say the full name of HSJCC. We speech pathologists like to make our names as complicated as possible. So CDAC, their board, chaired by Hazel, and their executive director, Barbara Collier, has, they worked for years to develop the Communication Intermediary program, and did a ton of advocacy around the Accessible Canada Act, which I will touch on here, to actually have communication disability included in that definition, which is a huge step, and certainly not always the case in provincial legislation. And so as that organization has shifted, and Barbara moved towards semi-retirement, she had asked if, it was very important to them that this program around communication intermediaries continue. And so CAJust was born through, the support of CDAC and their board, and Barbara, certainly. So I do just want to comment on that. And I think, something that can be tricky as a nonprofit, there are all kinds of rules about, advocacy and what does that look like and who we can advocate for. And so you'll notice I talk about promoting access to the justice system and education about what a CI is, how much they're needed, because I think, something that's a real struggle for people, our brain is a little black box. We do a lot better as human beings. We see something, we see there's a visible, perhaps physical difference or disability, and that's, our brains really get that. But the brain is so complex, and it's like a little black box, and we don't necessarily understand it. So I think there is a huge need for education that I'm still working on. And that's part of why I'm here today, and thrilled to be here to talk to you. So, okay. So, communication disability. So there is no, in fact, not dissimilar to the term disability itself, there's no universal definition of communication disability. And I'm going to speak a little bit to why within the Canadian context of our justice system, the term disability is so important, because I think there are also some challenges with that term that I like to be really conscious of. And so I'll address that, but I'll ask you to take me on at my word that currently in our system and the way our legislation is, the term disability is quite important. And so the thing about people with communication disabilities is that they tend to be vast and varied in the underlying cause of some of the challenges that they have, and in terms of perhaps the groups that they identify with. And so that, I think, has presented a challenge for individuals with communication disability, because there was never any one umbrella. And so in terms of those groups doing advocacy to bring these concerns to the awareness of, of the individuals who make some decisions, that's been a real struggle. And so that's really, I think, something that Communication Disabilities Access Canada has really done, is said, listen, there may be many different reasons, and we're going to talk about what some of those underlying causes can be. But at the end of the day, the function, the difficulty with speech, language, communicating, whether that's, in a social context, some of those social communication cues, or the impact that our thinking skills, our cognition has on our ability to communicate, whatever the underlying cause is, what we see is a significant group of people with those same challenges. And when we see that in the context of especially the criminal justice system, but really the justice system, we see this huge mismatch in the demands on communication to be successful, interacting with the justice system, and where some of these individuals are in terms of their abilities and challenges. I do just want to acknowledge, and I know Dominica very graciously sent me a number of questions ahead of time that people had about this presentation. And what about vision and hearing? And of course, these sensory, whether it's differences or, depending on how you identify, they have a huge impact on communication. And so what I will say is CAJust is largely focused on these communication disabilities that result from non-sensory differences. And the reason for that is there are some really excellent groups who are providing those services already. For example, if, for individuals who speak a signed language, for example, ASL, there are ASL interpreters. I don't want to begin to say that there aren't challenges and a lack of accessibility and problems for individuals who have these differences accessing and these disabilities accessing those services. But I will say that, you know, there are wonderful organizations who are working every day to make that happen. And so it's not to devalue vision and hearing differences, disorders, disabilities, but it is to say that's not our area of expertise. And there are well-established accommodations for those individuals. And the challenge is more actually having those come to fruition and be offered to those individuals interacting with the justice system. So, okay, I want to talk a little bit about why the word disability is so important. So Catherine did a lovely job of mentioning a number of the other jurisdictions internationally, those that are, you know, if we think about those Commonwealth countries, you know, share a lot in common with us in terms of their justice systems. And in those countries, the intermediary role, or the communication intermediary, the registered intermediary, they do actually use slightly different terms depending where you are. In New Zealand, I think the term is communication assistant, but the underlying function is the same. However, the way that those services have come into being is a little bit different than in Canada. So in the UK, there was actually a bill passed called the Vulnerable Persons Law, and that bill, so essentially there was a law and there was a top-down, in a sort of positive way. We don't often say that, but in a positive way, there was top-down legislation specific to intermediaries that didn't focus specifically on the word disability and didn't require that term necessarily. In New Zealand and Australia, which do actually have different systems, but parallel, there was really a bottom-up kind of push to and now in New Zealand there is actually a national approach, but the need to use the word disability is not the same there. And in Canada, because of the way our laws are structured and because we don't yet have, and I believe me, big plans, I have big plans, you know, for 30 years down the road. But right now, the law is such, it's written such that in order to be accommodated, and that's another important word in our justice system, you must have a disability. Now, jeepers, there's a lot to unpack there, and I'm by no means again a disability expert, and I appreciate very much the learning that I've benefited from my colleagues who work in that space. But what's important to know is that disorder, difference, impairment, condition, and I say this with the utmost respect and appreciation for the impact that those things can have on someone's life, they mean nothing in the context of the law, which is shocking. It's shocking, but it is, you know, it is the law. And should that change? Absolutely. Let's work on it. But in the meantime, let's use the system that we have. But the challenge then presents, and actually someone asked this question ahead of time, what if the person you're working with doesn't identify as having a disability? And this, I will say, I have experienced, it's similar to Catherine, do a fair amount of work in my other life as a speech pathologist with individuals after, whether that be a traumatic brain injury or an acquired brain injury like a stroke. Many of those individuals, especially if they don't have visible physical disabilities, don't identify as having a disability. And so, you know, there's this whole and I think really insightful movement, this idea of nothing about us without us. You know, there's this ableism thing to say you're like, you know, you have a disability, and really, you know, my learning would suggest that many people would say, actually, you know, I can self-identify as having a disability, but it's not within your purview. And so I say this with the utmost respect, and it's a conversation I have directly with individuals I'm working with as a communication intermediary to say, I don't know if this is how you identify, but I do explain why I'm using that word if I do in my report or in my interactions. And that while it, you know, I want them to know that I have deep respect for their own choice and how they identify, but that if they, you know, if they would like to access these accommodations, that word is honestly required. And is that fair? Is that right? Well, we could have a whole nother day's talk about that, but I do just want to acknowledge that. What about neurodiversity? And so I think there's just such a huge field there. And again, I hope that those, people really working meaningfully in those spaces do have an impact on the laws going forward, and I'll be right there cheering them on and doing my part. But I just wanted to acknowledge that, and I'm happy to answer questions about that. But just to be aware that that's how we're going to move forward in this conversation, and that's why. And yeah, so in terms of what is a communication intermediary, so in Canada, and again, so in the UK, for example, they do actually have allow for a slightly broader range of individuals to become a communication intermediary, because they do use intermediaries for mental health. And again, that comes from there, which if there are any individuals working with individuals with mental health challenges on the line, which I know, Catherine and myself, there's a lot of that intersectional disability. We know that those individuals could absolutely benefit. But in Canada, that's not what a communication intermediary is. And in part, that's because our training is not sponsored by the government. And so we kind of need communication intermediaries coming in. We need speech pathologists to have a real strong background in communication and language, because we need them to have, all of that understanding and knowledge. And then we can teach them the part about how does that, how does your role change as an intermediary? What does it look like to interact with the justice system? Really important to understand. And again, to navigate my experience in navigating, especially the criminal justice system, is that the intermediary is there to facilitate two-way communication, right? Because in theory, the court's intent is to hear every Canadian's best evidence, right? So the court wants to hear the best evidence of everyone. And so to facilitate both for that individual to give their best evidence and the court to hear that. So this is a two-way responsibility that the intermediary has to help, let's say, whether that's police or attorney or justice, communicate effectively to the person with the communication disability, and vice versa. Okay. And that's what makes them a neutral officer of the court. Okay. Because their responsibility, and this sounds really sort of, I feel like it sort of makes a CI sort of sound a little bit, snobby is not the word, but I kind of find some of the language in the courts and stuff a little bit highbrow, high-handed, and so I think essentially they're in service to justice. Okay, I know many of you are. The things that a communication intermediary, while they may want to be in their heart, cannot be as a CI, which is you are advocates, you are support people, you are, you may be experts in the population that you work with. A CI in their role as a CI is not those things. So it's really important to understand that even if a person has a CI, they still, if you can have a victim support worker, if you can have, they need an attorney, they need, all of these pieces. And while that may be, my experience is that actually can be very hard as a communication intermediary, because you might be, involved and facilitating an interview with police and someone who has is reporting a sexual assault, and it's incredibly emotional for them and incredibly difficult, and your role is not to support that person. Where in another context that might be my job. I might be an advocate as a CI. Your job is to support that interaction, to allow that person to tell their story and to allow that officer to really hear it. So okay. CI basics. So a question that comes up over and over, and I think especially in the desperately underfunded justice system, is cost. So who pays for it? It's really important that the cost is paid by the end user. And what do I mean by that? Well, because in theory, our justice system is there in service to justice. The end user is, if police need to do an interview and they need two-way communication facilitated, it is the police service who is paying for that CI. In the court, so if you're going to a courthouse, it is, the court, or in the end, depending on how things are structured, a Crown might say, well, the Crown is paying for it, even though it's an accused person who requires that. In the end, it does come from the person in the police or justice context, the professional who needs to talk to the individual with the communication disability. And if you think about it in terms of, for example, a language interpreter, if I walked in and, I am an accused person or a victim or a witness, and I speak Spanish, and I say, don't worry, you don't need an interpreter. I've brought my sister. And my sister may be very proficient in both languages, but we don't have friends or family or someone paid by the individual acting as the language interpreter. Why? Because we need them to be neutral, right? And so this is part of what ensures that neutrality. Accommodation. So communication intermediaries are an accommodation provided by the court or police, RCMP. And again, I would draw those similarities. And of course, there are differences with language interpretation, right? So while now, this is an overgeneralization because I know there are actually quite a few subtleties, for example, dialectical differences in a variety of languages. But if I speak the same dialect and the same language as you, and I have expertise in that language and in English, I should be able to walk in and provide interpretation services. With communication intermediaries, it's different because, and herein lies the rub, is that every communication disability is different. And so we'll talk about, well, how does that work in terms of services? And as I say, neutrality. And I come back to this over and over because what I often hear as a first line response, let's say from police or even attorneys, is they'll say, oh, you have to let we can't have anyone else in here. It's got to be the person talking for themselves, right? They're afraid of biasing the evidence and so it's really important as communication intermediaries that we maintain that neutrality. So that's why I highlighted it again here. So how does CIs work? What does that look like? So because of the difference, because each individual, and just, taking a moment to speak to some of those, traumatic brain injury is an area that, again, I know Catherine works a lot with, and as do I. And many of those individuals may actually not have specific language difficulties, though some of them do, but their communication is hugely impacted. So I'll give you an example. If someone has changes to their thinking skills, and whether that be from a traumatic injury or a developmental difference, right? So an intellectual disability, when you have changes in your thinking skills, if I cannot attend, right? If I do not have the ability to pay attention long enough to hear what you're saying, then I certainly can't move it up to my brain, make sense of the language, hold on to that, and then respond, right? I certainly remember it? Absolutely not, right? And it goes all the way up the chain. So there's all these pieces that when we have changes to our thinking skills can really affect how we communicate. And again, I know many of you are working in the trenches with people with these challenges, and you're saying to me, yeah, obviously. So I don't want to belabor the point, but I think, you can be working with someone with a traumatic brain injury. Someone asked about FASD. So I think that's, in Manitoba, we actually have an FASD court, which is interesting. There's no communication supports currently involved in that court, which is something I'm working on. But FASD is something that, we've got a significant prevalence here. It's, underreported and underdiagnosed. And again, I think a lot of that can be related to some of the stigma that mothers face when talking about these things. And then lack of services. I think the wait for an FASD assessment here in Manitoba is 2 years, unless you're involved in the criminal justice system, and then then you can get an assessment quicker. So anyway, I apologize for my slight cynicism there, but so yes, absolutely, some of the cardinal features of FASD when we think about FASD and kind of those brain domains in which you need to have impairment to be diagnosed, we talk about receptive and expressive language. So our ability to understand what we hear and our mental dictionary and our ability to get those words out and to know the words. Executive function is huge. And again, we see that in traumatic brain injury. We can also see that in developmental disabilities. So, having difficulties in those areas is absolutely going to impact your ability to communicate effectively, especially given the extremely high demand of the of communication skills to be successful. So all that to say, if we look at the assessment that the CI is going to do, their job there is to determine what this person's abilities are. Are there any, and in the context of them knowing what the demands are of the criminal justice system. So because if we think about disability, and I'll talk about this a little bit later, that's really how we identify disability. If we look at that WHO model of disability, we say, disability is in part created by, by the demands of the situation, right? By those barriers. And so what that CI is doing is they know what the demands look like on communication in the criminal justice system. And they're going to determine what this person's abilities are and then look for the mismatch if there is any. Then they're going to look at which accommodations might be effective. We always invite the end user to those assessments. I'm not sure I've ever had one come, and that's not a criticism of them. I think that's just the reality of the busyness of their schedules. We do not discuss the case. Okay, so as a CI, we're not discussing the case. So if you're in a CI assessment with someone you're supporting and you're like, well, they're not talking about the case at all, that's intentional. Okay, we are really focused in that appointment on looking at their communication abilities. Then we're going to provide a report, and we're going to identify whether or not there is that mismatch in abilities and demands on communication. So is there a communication disability in the context of the justice system? And then we'll also describe all the accommodations that we feel are necessary to ensure that accurate two-way communication. And then that's going to be, so let's say police have asked for a CI, that'll be provided to police. And something to be aware of is those reports. So let's say it's an accused individual, that report will eventually be available to their defense counsel, but also to Crown. So I'm always very careful, and it is something to be aware of as whether you're an advocacy agency, a support person, if you're counsel, if you're doing any of those things, if there's information that doesn't need to be in there, don't provide it as background history. If there's things that you think might be prejudicial that you don't want in there, that you think may negatively, about, sometimes I'll get years of a person's history, medical history and things about their experiences in CFS. And if it's relevant and helpful to that individual, absolutely, please provide it. But if you think if it's not relevant and it's not something that you want available or this individual wants available to the whole court, then that's not something that you want to provide to the CI, because again, that report is going to be going to the court eventually if that's where things head. So something to be aware of. So all of this has to happen before a CI can do their work. Whereas a language interpreter, if you confirm they know the language and the dialect, they can walk in and do it. But this has to be done first. So it's important to be aware of. And we're going to talk a little bit later about why it is also so, and I think you can kind of already probably in your minds are thinking, oh my goodness, we got to do this early. Yes, the sooner the better, but it's never too late. Then the CI is going to provide those intermediary services. So, and what those look like are going to depend on the abilities of the person, the demands of the situation, and then the ability of whether it's a police interview or counsel or the justice, when they're talking to that individual with the communication disability, can they use the accommodations themselves? Now, this is not a criticism of those individuals. They are trained to do their job. They're trained to be an officer. They're trained to be an attorney. They're trained to be a judge, and they have a lot of responsibilities in the context of those roles. So it is very hard because to then take all these accommodations, like, not using any compound sentences or complex sentences. Wow, that's actually quite hard, especially in the language of the court, because they have scripts, and you'll hear it if you've sat in enough courtrooms or police interviews. They have sort of scripts in their mind, which makes sense. We all do, right? We kind of have a way that we communicate effectively in our respective professions, and so we use these scripts, and they are not conducive to someone with a communication disability. So it's very hard for them to implement those things as they talk, right? So, but sometimes people have an innate ability to do that. So the reason I mention this is, just like a language interpreter, the CI is providing synchronous or in the moment supports. Okay. So, for example, and I've given a little example. That was thoughtful of me. Always nice when you can thank your past self when you're in the present, because there are times when you're doing the opposite. So let's say there's an interview and a detective is asking a witness a question. If that question is formulated such that it meets with what the CI knows are the abilities of that individual, they might just, they would sit and do nothing. My experience has not been that. My experience is that it's very challenging for an officer or an attorney to do that, because there really is almost, I'll talk about this a little bit later, they have their own language, right? And their own vocabulary. And I know a colleague of Catherine's, Dr. Lynn Turkstra, did an interesting study where she looked at individuals with traumatic brain injury and their ability to understand the vocabulary that is used in the criminal justice system. And I can say probably 0 people were surprised to see that it was very, very difficult for them. And so, a CI, when you watch a CI work, you might see them do nothing. You might see them take a sentence that someone has provided and separate it into 2 separate things. You might see, if we're talking about dates, the CI put a calendar down, anchor the person to the current date, and then re-ask the question that was previously asked by the let's say interviewer, while showing the person the date on the calendar. So you're going to see a lot of different supports and interventions depending on what the needs are and what the demands are. Okay, that was a very sort of quick overview, but I'm conscious of time. So what do CIs look like in the Ontario justice system? If you can't tell, I love this stuff, and I could talk to you all day about it, but occupational hazard, I'm going to say, but I'm going to try to move through this, and especially knowing that you've had the opportunity to meet, and hopefully some of you that are here today have heard from the MAG and their accessibility group, but I'm going to touch briefly on specific to Ontario, and I hesitate to say this because I don't want to devalue what I'm sure are the constant, and actually, in hearing, even hearing from Catherine with all her knowledge and abilities and connections, her experience and all the people that she's worked with, even just the challenge of navigating the process of having the MAG's accessibility group come and talk. There are a lot of challenges. And again, that's not a criticism of them. That's just the reality of the system. So I know all that. And now I'm going to say that CIs are probably the easiest accessed in Ontario of any province. So I say that all, not to devalue anyone's experience. I'm going to talk very briefly, high level about some of the legislation that is in place that does actually already support communication intermediaries. So something to know about the Accessible Canada Act, and I was so pleased with myself when I figured out how to change the link. So it just had, a nice word like Accessible Canada Act instead of all, but then I realized if someone just has my slides and they want to go to the link, it's very hard for them if they don't have a virtual copy. So I've left the link there, but what you can see is that in the Accessible Canada Act, which is our federal legislation, and jurisdiction is another challenging thing, right? Because while the legislation is federal, the province administers justice. But it's important to know that a communication disability is included in the Accessible Canada Act. Okay. And a huge, there's lots of, I'm sure, people involved in that, but I know that I do know that CDAC was very involved in that. So to be aware, it is part of the definition of disability in the Accessible Canada Act. The Canada Evidence Act, it's there are provisions. I know, don't go to sleep yet. Have another slice of orange. In the Canada Evidence Act, and I put this stuff in here so that it's there for your reference. I don't expect you to go through, but I think it's valuable to have and to know so that you can ask questions, and have a follow-up discussion about what this means. But essentially, what the court says is that a witness can have any accommodation that they need in order to be intelligible by the court when they have. Now, unfortunately, they have two broad terms: physical disability and mental disability. In my experience, communication disabilities are lumped under mental disability, which again, we could have a whole conversation about. But again, my focus right now is, while we're working at changing things and changing the law and improving things, we want to work within it and use the provisions that are there to help tell people what they mean. So again, it is there in the Canada Evidence Act. Now the AODA, again, oh dear, now oh boy, I've done it now. Okay, I might have to stop sharing because just for one moment, you're going to have to see my face again. I'm going to do this again, but I lost, okay, let me try again here. I'm so sorry. It was going so smoothly. Okay, let's do this. And we're gonna go again. Thank you for your patience, everybody. And then I'm gonna do this. Okay, so the AODA. So again, I'm not going to read this to you, but I highlighted a few. They've given a few examples in the Accessibility for Ontarians Act, with Disabilities Act, which actually is, and again, acknowledging the struggle, quite good legislation. And the challenge is more in how it's actually, and actually the standards coming from that legislation are very good, but it's what it looks like in terms of actually on the ground for you guys when you're trying to action those. But you'll see brain injury, which is, incredibly prevalent, and there's honestly a huge wide range of percentages. Catherine might speak to that more, but sometimes I feel like it's a bit like, I don't know, it's like 50 to 100%, it's sort of this huge, right? But what we know, it's wildly prevalent. And things like learning disability, language disorder, all kind of mental illness, all layer on top of that. So but it's in the AODA, right? They talk about speech impediment. Interesting choice of words, but again, we're glad it's there and we're going to make use of it. They also list things like developmental disability, learning disability, a dysfunction in understanding or using symbols or spoken language. So it's in there, okay? This group of individuals who has difficulty communicating is listed as a group who should be protected and supported by this act. Well, what does that really mean? And what does it mean for the courts? Well, you may have heard a little bit about what that means for the courts from the MAG. And so I'll go quickly again through that process, knowing that you've probably seen it, but I think especially important when we think about policing organizations, because a challenge there is that there are so many different ones. And so getting to them all, informing of them of, not just their responsibilities to accommodate, but how to accommodate. When I'm talking about communication disabilities, I would say a CI is very challenging. However, when we look at these standards, so the information and communication standards, so these are kind of the rules, the more defined rules that came out of the AODA, they speak to the requirement to allow for communication supports, not just allow, to provide them and pay for them, everybody, provide them, and to ask the person with the communication disability which supports they need. Okay. And so I think that's really critical. Something else to be aware of. I'm not with the Toronto Police Service. I took this logo from the website, but knowing that I was speaking to people in and around the Toronto area, this is just one example. But in their accessibility plan, they do speak to this information and communication standard from the AODA. They talk about the communication supports, that they have to be provided in a timely manner, and that they need to consult with the person making the request about the suitability of the specific support. So, police services are on my list in terms of providing education about these things, but there is information there about how to follow up. And so I would encourage you, sometimes it's less about, getting all the way to the finish line in those first interactions with police, and more about helping them understand that there are processes that you're aware of and that you need to stop before you have interviews, before you have these, these things that can happen in quick succession, because it's important for these individuals to know that they have responsibilities, and that there are ways to access them. And in fact, this is taken right from their own accessibility plan. So I wanted to highlight that, so that you're aware of it. In terms of steps to access a CI in the Ontario court system, and I've heard from Catherine and some of the sort of desperate frustrations that have come, not just, I know there's, a new very large sort of mega court, but across courtrooms where people are looking to, this just step number one, identify and contact the accessibility coordinator. And that's been incredibly difficult. You want to do it as early as possible. So if you're already now at the court stage, it's not too late to get a communication intermediary involved, but as soon as you know which courthouse you are going to be at, as soon as you are aware of that, taking steps to try to contact your accessibility coordinator for that courthouse. That may be their third job, especially for some of these smaller courthouses. They might be manager of services and like manager of court services, manager of this, and also the accessibility coordinator. So it may not be immediately obvious. In theory, there is a website you can go to. I shouldn't say that. There is a website you can go to that you can click on. You can search your courthouse, and there should be an accessibility coordinator listed there. The challenge that people have found is that, they go to contact that person and they've left that position. They don't get a response. So there are challenges. What their website says, and you can look, I've put the links here, is that, ideally you should have your court number, which court you're going to, the date and time of your proceedings. But honestly, I know lots of times you don't have that, especially as maybe a support person or an advocate. You don't have that because that information wasn't provided in an accessible way to the person you're working with. That's okay. Contact them anyways. Make that initial contact with that accessibility coordinator. Because that's the first step. And then say, I want a communication intermediary. In theory, what should happen next is that the court accessibility officer would retain a communication intermediary and connect either the individual or that designated support person with the CI to complete the assessment, because that's the first step. Then the CI would be providing that report to the court accessibility officer so that it's available to the court and to counsel. But what happens when that doesn't work? If you cannot contact the accessibility coordinator, if you can't get a hold of them, if they don't respond, if they say, I don't know what a communication intermediary is. And again, I understand that, there's lots of things they need to know. And so often they're just not up to date, especially if they're new. The feedback that I've had is that you can contact the Ministry of the Attorney General. Be aware that I think certain email subject lines get more attention than others. And I think sometimes, as professionals, we try to be really careful and not sort of too alarmist. I think the ones that say, human rights being violated probably get a quicker response if I'm being totally upfront. And that's, and that's not, it's because I think they get a lot of requests. So knowing that that is what's happening, right? If someone has a communication disability and they're not able to contact that accessibility coordinator, it's a really big deal. So you can also email me. And I have had a really wonderful relationship with the Ministry of the Attorney General. And I've had some success in, kind of bringing the groups together to make sure that you can get in touch with your accessibility coordinator. Okay, how am I doing for time here, team? 12:55. Okay. So I'm wrapping it up. So in terms of supporting communication, getting started with that, I mean, I will say, and I'm biased, but I think if we're really talking about, I think you need a communication intermediary, but we all know a lot of the time that's not feasible and you don't have one. So for you, if you're working with individuals who you suspect have a communication disability or have difficulty with their communication, the first thing I always check is, do they have difficulty with their vision or hearing? I've had someone show up and it turns out they're blind. They're blind. And someone saying, well, they won't read any, we send these letters, they don't read them, on top of their communication disability, they can't see. So I think, And and so I think that's, as a service provider, as a frontline staff, like I really try to make it my job to ask those questions of the individual. Don't rely on the referral, ask those questions. Really being conscious of this dignity and respect piece. And it's something that I'm so conscious of. And I imagine Catherine may have had some of these experiences too, but there's a huge amount of shame that goes along with communication disability. There's low self-esteem. Well, I'm stupid. And so there can also be some pushback in terms of, what do you think what do you think I'm stupid? You're saying I have a communication disability. You think I need to, get this communication, what is that? I'm not an idiot. And so sometimes there's pushback from that individual, and understandably. And so I think it's really important to kind of connect with that person and say, I know that right? It's all here. You've got it. It's all up here. It's just that we don't have a system that provides you with a way to get that out. And to really and to get the information in that you need, and to acknowledge that the criminal justice system has its own language. I was in court, and a defense counsel asked me, so did the king pay for you to be here? And I said to the judge, I said, I'm not, no, I don't know the king. I had no idea. He was referring to the crown, right? Right. Yes, Catherine, thank you so much for being on video, because that's how I felt. And then honestly, I felt a little embarrassed that I didn't make that connection. So I think really acknowledging, I know that you know what you want to say. I know that you know your story. I know that. And we don't have a system that lets you show what you know. So let's use the supports that are available to make sure that we allow you to show what you know. Okay. Probing for awareness. This can be tricky, especially for people with insight. So they may not have a ton of awareness of their difficulties communicating. So how do you navigate that? Probing a little bit to see, are they aware? Do they have awareness, or do they have, no, I have no problem talking to people, right? And you're thinking, oh boy, but we're having trouble talking right now. So, do they have awareness into that? And, that's going to affect how you kind of navigate that. If they have no insight, even in the context of this shame, this is something that I really think about. And I think, and again, just to be clear, I do have a huge amount of respect for, and I work with wonderful colleagues within the law. I have some wonderful colleagues in policing that I've had great experiences with. But what I say to those people is the system was designed a long time ago. In one more sort of colonial stroke of, what, it was designed to keep the public out and to keep them down. That is what, initially it was sort of like, if, we don't necessarily want participation from the public. And so the language was meant to be for people who had been through that schooling. It was meant for the judges and the lawyers and the police. It wasn't meant for the rest of us, right? And so we want to make sure that they have the tools that they need so they're not left out. This is something that I think about a lot. Just being really careful about the jargon that we use. So on the night in question, did you attend the residence of Mr. Adams? I don't know. I don't know. No, it's a response we often get, because that question, you may have lost them with the preamble that you gave them, right? So pulling out a calendar, an individual, and saying, hey, did you go to, and also Mr. Adams, did you go to John's house tonight, or whatever term they are familiar with for the person you're talking about, on January 24th, right? That's going to make a huge difference. Confirming comprehension. So we're helpers. I think all of us are here today, and I'm conscious that I've probably gone over. It's 1 o'clock. Okay, I'm going to try and wrap this train up. But I think you're here because you care and you want to help people. And that may be in a variety of different sectors and in a variety of different ways, but we want to help. And we have a real yes bias. We ask questions because we think that the person might be having a problem with that. Are you cold? Are you hungry? And we have to be careful that when we're confirming comprehension, we don't only ask questions that we expect a yes response to. Because if someone says yes to everything, if they can say yes to everything, and that will, sort of confirm their comprehension, quote unquote, then you have no idea if they've understood. So you have to make sure that you ask, it's not trying to trick anybody. It's just you as a conversation partner, being conscious that also my experiences, whether with victims, with survivors, with accused, with witnesses, men, especially in marginalized populations, they are used to being given a hard time in these situations. And so they may very reasonably say whatever they think they're supposed to say to not, get hit upside the head, not, literally or figuratively, right? And so, I've had people, yes, sir, yes, sir, yes, sir, yes, sir, right? So we have to be careful. And that's how we can help to know, okay, is this person that I'm working with, that I'm talking to about their options in terms of accessibility, do they understand, or have I lost them? I will also have the conversation and say, hey, I'm here. I know you may not have a reason to trust me, but I'm going to tell you the truth. You may not always like what I have to say, but at least you know you can trust me. One thing that I really need from you, and I know this is hard, is to tell me when I'm not making sense. That's a me problem. That's not a you problem, right? But really try to, and then if they do ask, if they give you a face, say, oh, thanks. Thanks for saying that. I realize, let me try again. I didn't say that right, right? Another way to say it is if someone, again, we want to be really conscious of that shame and not talking down to people, but saying, I just want to make sure that you understand. And then give a quick summary. If you can, through the 3 things you just spoke to. And then also something that I will do in conversations is asking, maybe a similar question, the content of the question, but where in order for me to know that they've understood, I expect a yes answer at sort of maybe the start of the conversation and a no answer at the end. And if you're like, wait a second, those answers aren't consistent, then there's been a miscommunication. Yes, no questions. What if the answer isn't yes or no? Caitlin, do you like peanut butter? I don't know, but because I'm really, really allergic to it and I need an EpiPen for it. But I can't dislike peanut butter on principle. So sometimes if someone is really limited to those kind of yes, no, or small, shorter responses, and we ask a yes, no question and they look at us funny, people say, oh, they don't understand. Sometimes it's because the answer isn't yes or no. So acknowledging that to the person and making sure they have a way to say it's something else, right? Sometimes yes, no questions can be really hard. And in fact, harder than some other closed-ended questions. So multiple choice and things like that. So you can be aware of that. Visuals. You probably can't see me, but I am a hand talker. And it helps, right? If you're talking about yourself, point it to yourself. If your pronouns are the worst, and they're very hard for people, many people with communication disabilities to, and by that, I don't mean everyone's entitled to their own pronouns, but because they're vague, right? She, he, they, them. Who are we talking about? So pointing to the person that you're talking about, all of these things can be really, really helpful. I always have blank paper and a Sharpie with me. And writing single words, drawing what you're talking about, using a simple timeline. Okay, I said pronouns are really hard. I'm going to say time is even worse. Time is such a complex, abstract concept, especially if you're if you're currently in a lifestyle where time, like, yesterday, today, November 23rd, November 24th, it's really not having a major functional impact. You're focused on getting your basic needs met, and it doesn't matter. So you're not necessarily going to be tuned in to that time. So writing a timeline, I will write a line across a page, right? This is today, and then show things before today and things after. It can make a huge difference in your ability to communicate with individuals. Okay, I've the cardinal sin, it's 104 I've gone over, but something to be aware of: who, what, and where questions. Again, vast generalization, but they tend to be easier to understand. They develop first in kids, and we tend to understand them a little bit more easily because they tend to be a bit more concrete, right? You can usually, not always, but it's easier to see a what than it is to see a where. It's easier to see a who or a when, sorry. It's easier to see a who than it is to see a why. What does why look like? Right? Very complex. So why did you do that? That can be a really hard question to answer. And so it's just good to be aware of that. I would encourage you, a CDAC, I have no, I have no sort of monetary or interest or anything like that, but they did go through a ton of work and create a lot of presentations about how to communicate with people with communication disabilities. So I'd encourage you, and they're free, so I'd encourage you to check them out. I'm not sure, like, they don't have a ton of funding. They have no, so I'm not sure how long they'll be there, but I would encourage you to check those out if you've now been inspired and are as passionate about people with communication disabilities as I am. there were a lot of questions about, and by a lot, I mean, a handful of questions about resources for individuals who identify as deaf or, hard of hearing. I am not the expert. Looking for accommodations for vision and hearing. It's that same process for courts that I outlined. I would encourage you, I did just do a little bit of looking and found quite a good document. It was done by the Canadian Hearing Society in partnership with the Ontario Law Foundation, just speaking to the barriers, some resources. But again, honestly, you're going to find far better resources from people who do this for a living, where they're really immersed in the situation. But I didn't want to offer you nothing. That's it. Okay. I know that I've got this slide up, and if you can see it, you can see that it's got this sort of watermark over it. But I just thought, like, doesn't this just define all of us in a presentation, especially a virtual one? It's like, oh, I have a question, but I feel so awkward. So I had to put it in anyways. Okay. I've covered it. I'm sorry I've gone a little bit long, but I'm happy to answer questions. I'll stop sharing so that you can kind of look me in the eyes, and don't hesitate to send. I think, did I do that, Catherine? Did I stop sharing? Okay, great. So yeah, please don't hesitate to reach out. I've provided my email, our admin email. This is my sort of my volunteer job. I do this sort of not because I value it any less, but just because oh, that's wonderful. Yes, absolutely. So Catherine's just put some more information in the chat as well about some resources. Honestly, there's, a myriad of the actually the Aphasia Institute. Now, while many of the individuals we work with may or may not have aphasia, there's something called supported conversation that they do training in. And honestly, while it's really great for people with aphasia, some of the basics that you'll learn in that webinar are really valuable for all kinds of different communication disabilities. So again, this is broad strokes, folks, and I hate to make generalizations, but I also want to provide some things that are functional and meaningful. And so I didn't put that in the presentation, but I think it's really oh, Catherine's doing it. Of course she is. So yeah, so I'll maybe stop there. And I think it's Dana that I'm not sure if there are questions in the chat. I haven't been looking.
Yeah.
Normally okay.
Yeah, so we do have a few questions. Thank you again, Caitlin. That was so informative. There's a lot to process, and obviously, you guys are giving us a great insight on what it looks like. So again, thank you. I'm going to go over the few questions that we have here. So of course, we are going to be sharing the recording with you. That was one of the questions in the chat, and we always get that question, and we know this. So happy to share that. So one of the questions, Caitlin, it says, they're wondering about the access to French services or procedures as it is an official language. It's an extra challenge, as we all know, when folks are also have mental illness and brain injury. Can we request that support?
Yes. So two thoughts here. One, there are, and I should have checked numbers because actually that was a question that Dominica sent ahead of time. There are speech pathologists who work both in English and French who then have trained as communication intermediaries. So, but in terms of, would that, there's not, well, as the question asker has highlighted, there's not a ton of bilingual SLPs who are trained as CIs who are working in every jurisdiction. So yes, it's an added barrier. But what I will say is that as a CI, I have actually worked with a language interpreter. So there was a gentleman who spoke an African dialect that was quite unique, and his language interpreter came in, and the question would be asked. I would provide the communication supports. The language interpreter would then do the exact same thing using the visuals that I had laid out in that client's first language. So I think as I say, there's no question it's harder. And ideally you'd have a CI who was speaking in French and who was bilingual and fluently bilingual sufficiently to work and be confident in that area. But if not, all is not lost. That is absolutely something that I have done actually, and quite effectively, to be honest. It's slow, of course, but to me. And that's, you know, I appreciate the patience of the individual with the communication disability where they are speaking another language, but it's not, I think that's the thing. It's not impossible. And often you'll get pushback and say, well, we don't have someone that speaks French. That's okay. I imagine they have French language interpreters and they can work with the CI. So yes, there's my answer there. I'm always too long-winded, Dana. Hit me with the next one.
Sorry, let me
Or-
unmute. I'm talking to myself.
That's okay.
And then also just to add on to that, so if people don't know, Barbara Schreifer also offers the interpreters as well. So that's a resource to link to if interpreters are needed. So I don't have the exact information on hand. But yes, Barbara Schreifer Clinic is access to interpreters. Okay, next question. Once flagged or identified, is it a mandate that justice procedures must be halted until the CI report is received? And how quickly can CIs generally respond? And can one go directly to the CI registry if trouble accessing an accommodation coordinator?
Yeah, great question. So time is always a challenge. And should they stop? Yes, they should. Like, and that's in part why like the process should stop. And that's in part why I have included that legislation, because they may not, you know, I'd like to give the benefit of the doubt. If my husband were here, he would say the opposite. He'd say, assume the worst. But I love him anyways. But I like to give the benefit of the doubt. They may not know that the legislation actually does require that, that they do stop until a CI assessment and report has been completed. How quickly can it be done? Again, it will depend on your location. For those of you who are joining outside of the GTA, there's no question that as with many services, I live in Winnipeg, and again, we have lots of rural areas where this is a struggle. It's harder in areas where there are less CIs, and there are less CIs in smaller areas. Within the GTA, I would say, you know, typically there are a few people who do a lot of this work. And so the response, like I would say, it can be often done within a week. But that all depends on, you know, having access to the person. And so the CI will go to, like, you can come to, let's say, their office, but a CI will also go, I've done assessments in correctional facilities, I've done assessments, you know, all over the place. So that's not a barrier, but like you said, you know, helping the justice and legal professionals and policing be aware of their responsibilities, that is, it shouldn't be, but it is, I would say my experience is it really is incumbent upon the individual with communication disabilities and their support people. Again, 30-year plan, we're going to change things, but in the meantime, yes. And so I would arm yourself with some of these in a positive way, and those again, assuming the best in people, you can come to those interactions and say, hey, you know, just want you to be aware, you may not be. Here's all this information. Here's information. Look up your own police service. They have to actually have an accessibility plan. And it has to be in keeping with the AODA. It can get a little tricky. So corrections, this is one thing jurisdictionally in Canada. The law is federal, right? So we have federal, it's the responsibility for legislation is federal for our criminal justice system, but it's sort of provided and through the province, right? It's under the province's purview. So then the province has its own little pieces that it does. Corrections, 2 years plus a day is federal. And so that's going to fall under federal responsibility. RCMP, federal responsibility. So there are these differences, but you should know that's why I mentioned the Accessible Canada Act, because there are these same requirements. The standards they're still working on developing the standards that have come from the ACA, but there are responsibilities across jurisdictions. So yes, they should stop. Do they know they should? Will they? That's a whole nother ballgame. I will say there is now a wonderful court precedent, which I will, you know what I'll do is I'll add it to my slides for your reference, and then you'll have it. it's in an Ontario courtroom. There was a woman with an intellectual disability who also had a communication disability. She was interviewed by police who, unfortunately, it sounds like very supportive officers, but weren't aware of communication intermediaries. Did this interview. It looked the way it looked. She struggled to participate because the accommodations weren't there, and show all that she knew, right? It then went to court. The Crown became aware of communication intermediaries, had the assessment done, and her testimony in court looked radically different, just as it would, and I tried to provide, but then unfortunately that was used against her. It was used against the witness by opposing counsel to say she's inconsistent, right? Now, I would say to people there, it would be like interviewing me in Spanish. I have a few words, right? Like there's a few little pieces I could do, or even in French. I speak conversational French. I enjoy it. I try my best. I did immersion, and so I'm kind of functional. I can get by. But if I was being asked detailed and specific questions that I was then going to be held to in another language, I would look like I was lying when I was then interviewed in English, right? But I wouldn't be. It was because I wasn't provided with the appropriate accommodations. It's the same thing if someone is hearing impaired and they can't sufficiently hear what's being asked of them, right? And so I think that's my response when I hear that. All that to say, there's a wonderful court precedent. The justice ruled on the use of a communication intermediary in the courtroom. There was a hearing about it, and the Justice Fraser said yes and wrote a detailed written decision that supported the use of the CI. And in fact, in his decision on the case, which, personally, I'm disappointed, didn't, because the justice essentially said, I think this probably happened to this young woman, but the bar of reasonable doubt is very high. And so that was, frustrating. But what he did say is communication intermediaries are an important part of the accommodation process, and they did not negatively influence the course of justice. Huge. This is a really important decision that we hadn't had to date. And so I will share that because, again, you can know there's court precedent now in Ontario specifically on this topic. And that's something else that, honestly, in my experience, can sometimes, kind of make people slow down when they're trying to push things forward. When you say there's actually court precedent for this in Ontario, and communication intermediaries were ruled and were used in the courtroom, in fact. So again, we shouldn't have to get there, but that's something else that I would encourage you to consider. And I'll include that. I didn't show that in my slides, but I'll include that in my slides. I also have a number of other sort of documents that are relevant that I'll often share when I'm educating people. And I'm happy to attach those and send them along just so that you have sort of people feel more armed with knowledge and information and documents that support this to slow the process down. Yeah,
Thanks, Caitlin.
Yeah, thanks, Dana.
So we don't have any more questions, but I do want to remind people in the chat to please fill out the link for the evaluation. Dominica put it in the chat. I don't know, Dominica,
Dana?
can you pin it again? Yes?
Dana, I'm sorry to interrupt. I realized that I have a number, actually like 17 questions that were asked ahead of time. And I tried to hit on some of them.
Okay.
I included them in my
So
presentation.
can we go through those as well?
that
So
okay?
as Caitlin's going through those questions, and be mindful of time, that we also would like you to fill out the evaluation link as well, which is very quick. It's not going to take any time for the evaluation. So please, yes, go ahead, Caitlin. And
Okay.
if you can, oh, I see a quick message. Let me see if it's just, okay, that's just a link. Okay, yes, go ahead, Caitlin.
Okay.
Thanks.
Great. So there were some questions about hearing, about individuals who are deaf, about those. So I tried to address that. I'm not an expert in those areas. Something that did come up is if a parent is seeking legal guardianship for personal care of an adult with cognitive and communication disabilities, would this be a good opportunity to advocate for a CI? Oh my goodness, yes. And this is part of what is so challenging about this process in Ontario is that there's a capacity board, right? And there's capacity assessors. However, those capacity assessors are private. And so the challenge there is that really, if the capacity assessor agrees to assess the capacity of someone with a communication disability, they should also agree to the participation and funding of a communication intermediary. But again, because it's a hugely broad group, so it's in terms of educating capacity assessors about communication intermediaries, what their role and responsibility is, what their responsibilities are. It's difficult because there's not sort of one person you can talk to. But yes, absolutely. To me, when someone asks about assessing someone's capacity without a CI, I would say to you, that's like bringing someone who, let's say, has like challenges with mobility, and let's say they can't, they don't have use of their legs, and they would typically take a wheelchair, an elevator, and you take them to the bottom of the stairs, and you say, okay, I want you to show me your capacity for getting up the stairs. If you show me you can, right, without getting up the stairs without the accommodation, then I will give you the accommodation. Is that person capable of getting to the second floor of a building? Absolutely, right? But we have to give them the accommodation that they need, the elevator, to get up there, right? So is a person does a person have capacity for something? We don't know until we properly accommodate. And so that's what I would say. But I did just want to touch on that question because I thought it was really valuable. And if you have more questions about that, don't hesitate to reach out. I did actually have a similar question came up just in my daily work with CAJust. And so I wanted to speak to that. Is a speech impediment considered a disability? So again, this goes back to what is disability. Under the AODA, it's in fact specifically listed there. Now, is it, do you need a communication intermediary because you have any speech differences or impediment, as the term is used? For example, if you have a lisp, is it impacting your ability to participate in and engage and understand and express yourself? It may or may not be, right? And so to me, it's more about the functional, it's about that gap. When we're talking about disability in general, under the AODA, it's listed. But when I think about, do you need a communication intermediary and do you have a communication disability in the context of the criminal justice system, that's where we have to look at what are the communication demands of the criminal justice system. Oh, see, look at me, I'm hand talking again. What are my communication abilities? And if there is a gap, then yes, that's where in the disability lies. And that's the sort of the WHO definition of disability that is used in the Accessible Canada Act. And yeah, so hopefully that answers that question. I want to make sure I leave you guys with 5 minutes to fill out that feedback form. Someone asked about French. How do we determine, so what are assessment tools available to discern if someone has an undisclosed disability? What are some options we can provide if the communication disability requires assistive software? So, that's such a big question, and good ones. Those are two big and good questions. In terms of screeners, or, I kind of touched on some of the ways. So some of the basics that I gave you are also good ways to start to notice if someone is responding inconsistently to you, to some of the ways that I suggested communicating. That might be a time to start wondering, I wonder if there's a communication difficulty here. In terms of a screener or assessment tools that frontline staff could do, I'm sort of wondering if Catherine has some suggestions. I knew she would. See, I knew she would. I knew she was already looking them up. So I'm gonna wait there, and I imagine maybe she'll put them in the chat or speak to them. Unmute anytime, Catherine. Oh, you're muted.
Oh, yes, sorry. I'm just going to actually put in the chat. I and some colleagues created a website called Traumatic Brain Injury and Youth Justice. And I'm going to put it in the chat. We have a whole video on screening for communication disorders with and a downloadable tool, as well as some other accessible things. It's easily applicable to adults as well. So I'm just going to put that in the chat. There's a whole video and materials that you can get from the website.
Fantastic. Thank you so much. I will be viewing that later. So, and then this other piece about assistive technology or assistive devices. So what I will say is that assistive devices can be incredibly useful, but they are very specific. And so, for example, if someone has, let's say, limited vocabulary and they're trying to express themselves, simply putting a device in front of them may not solve that challenge. And so devices can be very useful, but but they do tend to need to be, an individual needs to be assessed by a speech-language pathologist, not necessarily a CI, but a speech-language pathologist, determine their abilities and their challenges, and then determine which, if any, high-tech device might be helpful. Because honestly, sometimes, and especially I would say my experience, and I can't cite research to you, but I bet you Catherine knows it. My experience for individuals with traumatic brain injury is that often, in terms of communication supports, high tech can be harder than low tech because it's very hard to predict what someone's going to want to say, right? And as CIs, we have to be very careful not to bias the witness. So how do you put vocabulary in there without, there's a whole bunch of pieces. And in terms of the thinking skills needed to navigate a device. So I see Catherine nodding, so that must mean I'm not off track. And there must be something to support me there. So that's great. Okay, it's 1:26. I'm going to stop. I think I have addressed as many of the questions as I think I can. We talked a little bit about invisible disabilities, and the vast majority. So I'll say this one last piece. CDAC had a brochure that when they were wrapping up, they sent to me for communication intermediaries, and it was really interesting because I had given that to an officer that I ended up working with on this sexual assault case, and he said, "Well, we don't work with people like this." And it was an individual who I think has CP, who was on there with a high-tech device using eye gaze. Now, are there people who have experience with criminal justice system who have that? Yes, absolutely. But the vast majority of the people that police justice are working with have those invisible disabilities. So I'll say that. I could talk forever, clearly, but I'm going to stop and just thank you so much for your time. It's been such a pleasure to share this information, and please don't hesitate to reach out.
Thank you. I'm just going to jump in here. Caitlin, thank you so much. We could clearly continue all day. I just also wanted to emphasize that Caitlin, all of the work that she does with Access to Justice Canada is as a volunteer, as is her time today. So just so incredibly grateful. Thank you so very much. It was wonderful, Caitlin.
It's a pleasure. Thank you for the opportunity. I really do appreciate it. And everybody, I hope